May it please your lordships. Lord, may I once again request your lordship to revisit Berubari for a minute. Lord, where we had stopped yesterday. Lord, that is PDF, Lord, volume 13, page 492 at 508, para 31. Volume 13, 492 at 508, para 13. 31, sorry, para 31.
PDF 508.
Sorry, my lord?
PDF 508.
Yes, ma'am.
So the way PDF number?
Volume 13, page 492 at 508, para 31. Which I read. I'm
Yes,
just taking
yes.
one line to be reread again to buttress my point.
508.
Lordships may see last 10 lines of that para 31. Last 10 lines. That's not very crucial because that's exactly what has happened. 370 is a clear, Lord, I would say, reflection of this viewpoint that, Lord, 8 justices of this court have taken.
Running page 6038.
My lords have got it?
1 minute, my 6038. running page.
Where is the young intern? Lordship.
We are also in the same.
I know, but Lord, there was a
No,
young intern who was helping Justice Collier.
At least
I
I'm
can't
trying
see
to
the
do it.
young
myself. Justice Kaul and me are totally newcomers to this.
Beware of my lordship justice, Lord. He doesn't appreciate those of us who are technologically challenged.
No, they've become pros now. My two brothers have become pros. Brother Suryakant, I had indoctrinated when we sat together for 2 years. We were together on the.
Learning experience even yesterday evening while going home.
But not, yeah, my Lord Justice Khanna would remember Delhi High Court Lord started it much earlier. That's why Lord, most judges from Delhi High Court are extremely pro.
We've been used to it.
Yes.
Been used to it. I think for regular matters, I found it to be extremely helpful. It's very convenient.
I escaped it.
See, some state governments are very supportive. Others, are. I remember the time of the pandemic. I won't name the High Court. They didn't have money to pay for the licenses for the video platform that we were in. So dust cheap. We just withdrew some licenses from the Supreme Court and transferred it to them because they were absolutely in a dire state. And at that time, there was a lockdown, It was impossible to run the court without video conferencing.
But if your lordships can carry this into Lord, the lowest of the courts, Mofizil courts, Lord, it would be the greatest contribution
Now,
that your lordships will end up.
phase 3, we have a huge budget. So we are in the process of doing that, setting up our own cloud software for video conferencing.
And Lord, your lordships, there will be at least continuity since all your lordships are here for at least next, Lord, several years. So, now, Lord, last 10 lines of this para. This power, it may be added. The words, this power, it may be added. My lords have it?
Yes.
This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question as to how treaties can be made by a sovereign state in regard to a cession of national territory and how treaties when made can be implemented would be governed by the provisions in the constitution of the country. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the Constitution and subject to the limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on provisions of the Constitution itself. Now, Lord, in my respectful submission, the treaty in question here between the erstwhile ruler and Lord, the Governor General, which ultimately, Lord, that has now been transfixed into Article 370. So, Lord, 370 is an extraordinarily unusual provision. It's never, Lord, I mean, it's something which is so beautiful that, Lord, the constitutional framers felt that how do we give, Lord, a kind of respect, kind of acceptability, kind of, Lord, validity to this, Lord, letter of accession. So they, Lord, devised, as I said yesterday, Lord, it was an absolute, Lord, brilliant statesmanship on their part to bring that into constitution to assure people of Jammu and Kashmir that we mean what we say. We are not going to do away with this. So, my lord, that's why, my lord, this is very important that treaty will have to be interpreted in the light of 370. It's now, my lord, virtually, my lord, transposed into Article 370. Now, my lord, in the light of this discussion, please see, my lord, at page para. Therefore, our conclusion is para 44, my lord. Page 515, para 44, just first sentence. And this becomes even more important now. Therefore, our conclusion is, and Lord, in my respectful submission, Lord, no, it's a view which is, Lord, inescapable, and Lord, it binds your Lordship, since, Lord, this is a judgment of a bench of 8 learned judges. Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purpose of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that law necessary to implement the agreement has to be passed under 368. Now, concession follows the conclusion. So, Lord, it can't be said that it is on a concession. The conclusion of your Lordship is very categorical that legislative power is not possible. Only a constituent power can be exercised in respect of this. And that constituent power is under 368. So, Lord, in my respectful submission, far from President exercising the powers. And I will show, Lord, why President had become functus officio. But, Lord, even assuming that, Lord, 373 survives, which it doesn't, in my respectful submission, even then, Lord, the power could only be exercised under the constituent power. No other way. Now, Lord, please. This is a little important because your Lordship rightly, Lord, raised the issue as to, Lord, the definition of union territories in Article 3. Lord, originally it was not there. It was brought subsequently by, I think, 17th Amendment to the Constitution. But your Lordship said states do not include territories. Kindly see that. Page 516, paragraph 47. It would not be out of place to mention one more point before we formulate our opinion on questions referred to us. We have already noticed that under the proviso to Article 3 of the Constitution, it is prescribed that where proposal contained in bill affects the area, boundaries or name of any of the states, the bill has to be referred by the President to the legislature of that state for its views. Therefore, within such period, it is prescribed, it has been heard before us, so and so. Then, my Lord. No, I'm sorry. I'm sorry. I missed that page. It's earlier page. It is significant that Article 3. It is significant that Article 3 page 513, Manoj. My apologies, sincere apologies. Page 513, para 40. My sincere apologies. It is significant that Article 3 in terms does not refer to the union territories. And so, whether or not they are included in the last clause of Article 3A, there is no doubt they are outside the purview of Article 3B, C, D, and E. In other words, if an increase or diminution in the areas of the union territories is contemplated, or alienation of their boundaries or names is proposed, it cannot be effected by law relatable to Article 3. This position would be of considerable assistance in interpreting Article 3C. So, Lord, Parliament then, Lord, amended, and 18th Amendment. That's the joy of having somebody like Lord Gopal sitting next to us. I must, Lord, confess to your Lordships that I have sufficiently been instructed, briefed, and educated by Mr. Prashant Bhushan in this matter over several, Lord, sessions. So, because, Lord, he is appearing with me, and So, Lord, it's something which I must not say that it is. Now, Lord, please turn back to that para that I was reading, para 47 at 5 and 6. And your Lordships will find in the middle somewhere on the other hand, which is that 10th line from the top, on the other hand. Page 5 and 6, para 47, in the middle somewhere, on 10th line from the top. On the other hand, it is clear that if the law in regard to implementation of the agreement is to be passed under Article 368, it has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house, and that is a safeguard provided by the article in matters of this kind. Please see the language. But this is the protection your Lordships have extended, and I beseech your Lordships to extend it further.
Constitution.
Your Lordships to extend this further. That this is how you can't, Lord, resort to, Lord, some kind of executive power, authorize president to do this, Lord, do away with everything that Article 3 provides in the garb of, Lord, 356 powers. It makes complete mockery of constitutional safeguards. Because your Lordship knows what majorities can do. We have seen, Lord, what happened in 1975. So, Lord, this is the check. And that's why, Lord, constitutionalism, your Lordship's, Lord, duty to, Lord, the Constitution, to, Lord, ensure that it is upheld by the executive and parliament in letter and spirit. If they don't do it in letter and spirit, this court will strike it down and must. So, Lord, these words, Lord, I now see answers, Lord, to the reference which was sent by the Honorable President. We would accordingly
Really,
answer.
everybody was decided at a time when explanation 1 and explanation 2 were not on the constitutional.
They came as a consequence. Your Lordship said,
They
right?
came as a consequence of Berubari
Correct.
to take into account what the court held, that the
Correct.
state would not include a
Correct.
union territory.
Correct.
So now really that issue will not survive because the whole basis was that state will not include a union territory. And therefore, you couldn't see that territory in exercise of the lawmaking power under Article 3. You had to amend the constitution.
That's what there are two submissions on this. One, that treaty to be interpreted in the light of what Constitution provides in respect of that treaty. And two, that if you want to now touch that treaty, you cannot do it by a legislative act. You have to do it in exercise of a constituent power. As I said, Lord, Constitution is durable. Lord, if it served the need of the hour on that day, doesn't mean that, Lord, that need must be wished away because you have a majority need. But in my respectful submission, the argument that Lord government is advancing before Lordships, Lord, does not bear out from plain reading of the constitutional provision. Now see, my Lord, chapter 21, the title, temporary, transitional and special provisions. Now, my Lord, I accept that 370 is temporary because it's titled temporary.
Yes.
But it is temporary from the perspective of J&K, not temporary from the perspective of the Indian Dominion or Indian Republic. The choice was left to the Constituent Assembly and therefore the people of J&K to decide whether you want to continue with this status or you want to be away from India. That was the choice, and I will show that note from Mr. Iyengar's, Gopalaswamy Iyengar's plot, a very express statement before the Constituent Assembly. So, Lord, he was chairing the committee which drafted Article 370. There were 8 members in it. And they did it because of the extraordinary situation. They realized that we are losing J&K out of our hands. Now you persuade, Lord, citizens of a state, a country, at that time an independent Lord state, to cede to you. They agree to session on clear
There is
understanding.
a question of persuasion by,
Sorry.
it was the Raja Hari Singh who requested the government of India that
I
time.
agree. No question about
No,
it.
you are
But
saying
the
that
conditions,
the-
historical conditions can't be lost sight of. Your lordships are right. Raja requested, but in that letter he expressly asked for this protection. In that letter, he expressly asked for this protection. The Governor General agreed to that. And that is why the Constituent Assembly debated.
That's what Mr. Sibal argued that after 1954, this 370 has become a permanent
Yes.
feature of the constitution.
Now just see, Lord. Just see, Lord, 370. Lord, 370 is, Lord, what? Lord, first and foremost, 370 is, Lord, that, Lord, Article 371C is most important. That's first. The provisions of Article 1 and of this article shall apply in relation to that state. Meaning thereby, all other articles will not apply. That's an emphatic statement in the Constitution. Article 371C. We have to begin journey of 370 with that. Then, Lord, they go forward and say in Article, Lord, B, power of Parliament, in Article B2, just a second, an article, Lord, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, my Lord, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President subject to this exercise of power under D. And read with the proviso, provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So if it is part of instrument of accession, in consultation. If it is outside the instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be understood in the context of 356 and governor exercising omnipotent powers. That's why it is not very important for your lordships to read this in letter and spirit. So, the constitutional provisions are now added by 1C and 1D. Legislative powers are added by 371A. 1A and specifically B. The power of Parliament to make laws shall be limited. Please see the words. Shall be limited, mandatory, to those matters in Union list and the concurrent list which in consultation with government of state are declared by President to correspond to matters specified in instrument of accession, governing accession of state to the dominion of India as matters with respect to which dominion legislature may make laws for that. And 2, such other matters in the said list as with the concurrence of government of state President may by order specify. Now, my lord, why is it temporary? Please see subarticle 2. Please see subarticle 2. If concurrence of government of state referred to in para 2 of subclause B, that is what legislative power of clause 1, or in the second proviso to subclause D of that clause, that's constitutional provisions, be given before Constituent Assembly for the purpose of framing constitution is convened, it shall be placed before such assembly for such decision as it may take thereon. Why? Because not democracy. You could only do it if Constituent Assembly approved it. It was a temporary provision. So the new Constituent Assembly is being now convened, and soon it may mean in the meanwhile, Lord, President may exercise powers in consultation with the state government under 1B or Lord 1C or 1D. They said, yes, they can. But you place them before Constituent Assembly for a post facto approval. So, Lord, it was never intended to be permanent. It is a temporary provision. And, Lord, the entire burden or entire onus or entire responsibility or entire power decision to make the applicability was left to the Constituent Assembly. This can't be wished away. This is a constitutional provision. President can't exercise powers like this and say 370 is now otiose, or it stands repealed, or it stands withdrawn. Now, in that context, please see Article 3, my lord, sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. So, my lord, he can either say it will be cease to be operative, or he can continue, or shall be operative, which means shall be continued, only with such exceptions and modifications, and from such date as he may specify. So, my lord, the power is both for President to continue or President to discontinue. If he wants to continue, we can continue in same fashion or with such exceptions and modification. But for President to do so, prior consent of the Constituent Assembly is a must, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues such a notification. So, Constituent Assembly will send a notification to the President or a resolution, and on that President alone can act. You can't rewrite this. It is not capable of any other understanding. It was therefore an exercise which was limited by an exercise which brought a temporary provision, but temporary in terms of the objects, temporary in terms of the actions to be taken, not by efflux of time. But time becomes important because the life of Constituent Assembly was only till 1957. Now, Lord, Constituent Assembly, as your lordships have been told, Lord, went into it in Kashmir. They said, we want to be part of India. We want Constitution of India to apply to us. We want Article 370 to continue. President accepted that and issued CO in 1954. End of the matter. Where does he then have power to re-exercise that power? It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened, but now Governor can send in and we can act on it. But that will be virtually not destroying this very express provision. And I respectfully submit that it is impossible to accede to that interpretation. It was a one-time exercise. It was not intended to be exercised again and again. Even Constituent Assembly was not given power to do it again and again. Supposing they passed a resolution later saying now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. So your lordships will have to look at it either way. That's why the word temporary is very meaningful as the heading of the article. So I respectfully submit that this article has lived its life, has achieved its purpose. Now 371 survives because tomorrow a constitution is amended and new article is inserted, which we would like to apply to Jammu and Kashmir also. President then seeks the government's view and then extends the article. So to that limited extent, perhaps this article 371 may be necessary. But 373 is very clear that applicability of Constitution of India per se was only in terms of Article 373. And once they decide that, then no, it is untouchable. It cannot be revisited. President became functus officio in 1954 so far as 373 is concerned. And your lordships have expressly accepted this position. In Premnath and Sampath Kumar, both your lordships have accepted this interpretation. I'll make it good to your lordships. Expressly, your lordships have said that. And that is the view. Now just turn to the view of Gopalaswamy Iyengar. As your lordships would recall, Gopalaswamy Iyengar was the Diwan or Prime Minister of Jammu and Kashmir for many years. He was later defense minister in post-independent India and one of the most respected Indians at that point of time. He was heading this. Now just see his page, PDF page. Which volume? Volume 8, PDF page 1175.
Document 5. Document 5?
Document 5.
What file? Documents volume 8.
Mr. Dave, if Article 370 works itself out and achieves its purpose once the Constituent Assembly for the state of Jammu and Kashmir has completed its task, then where was the occasion thereafter to issue constitutional orders post 1957?
That's for 371 to extend from time to time any amendments. Because there were many provisions of constitution which may not have been made applicable, or many laws which may not have been
But
applicable.
if you see the proviso to D refers to other provisions of the Constitution, which will apply subject to such modifications. Then matters which are referable to the IOA require only consultation.
Yes.
All other provisions of the Constitution require
Concurrence.
require the concurrence. That's the second proviso.
Right.
Then the sub-article 2, clause 2 says, if the concurrence has been given before the Constituent Assembly has given its opinion, then it has to be placed before the Constituent Assembly for its opinion and for its concurrence. So your whole argument is that
Article 370 has now worked itself out once the Constituent Assembly completed its task. But that would be belied at the least by constitutional practice, because even after 1957, there were orders which were issued, constitutional orders progressively modifying the provisions of the Constitution in relation to the state of Jammu and Kashmir. Which means that, really speaking, Article 370 had continued to operate even thereafter. Therefore, it would not be correct to postulate that Article 370 achieves its life, and what is the temporary provision really assumes a state of permanence in the Indian constitutional fabric.
Lord, may I respect?
Because then there was no question of us, of any constitutional orders being issued progressively from 1954 onwards, or
Article
1958 thereafter.
refers to those decisions which were taken prior to its constitution. So to that limited extent, Constituent Assembly's approval was sought for. But subsequently, once the Constituent Assembly goes, whatever, my respectful.
But then where is the power to alter the constitution at all?
No.
If your argument is right,
No.
then once the Constituent Assembly in 1956-57 takes its decision, there is no power to change any provision of the constitution in relation to the state of
No.
Jammu and Kashmir,
I respectfully.
which is contrary to what everyone accepted that
373 is only in respect of continuation of 370 or not. Now, they agree, Constituent Assembly agrees. Once it agrees that it has to be continued, then it becomes some kind of a permanent decision. Please permit me to reread that 373. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications from such date as he may specify, provided that recommendation of Constituent Assembly of State in clause D shall be necessary before President issues such a notification. So, idea is that you have to decide as a Constituent Assembly whether you want this relationship to continue or not. So, they took that decision.
No, what I was trying to refer to is this. Clause 2 of Article 370 refers to a decision. It uses the expression decision. The proviso to Clause 3 uses the expression recommendation. But the commonality between Clause 2 of Article 370 and the proviso to 370(3) is some decision or action on the part of the Constituent Assembly. Just give me a minute. Both require some action on the part of the Constituent Assembly. Clause 2 requires a decision and the proviso to Clause 3 requires the recommendation. Now, according to you, once the Constituent Assembly completed its task in 1957, there was no question thereafter of invoking the proviso to Clause 3, because then it's worked itself out and the substantive part of Clause 3 and Article 370 becomes a permanent feature of the Constitution. That's the submission. It's a submission worthy of consideration. Absolutely, we have to deal with the submission. I'm just trying to explore that submission. There is one internal inconsistency in accepting that submission, because if that submission is right, qua the proviso to Clause 3, then the consequence would be that once the Constituent Assembly completed its task in 1957, there could be no amendment to the Constitution at all under Clause 2 of Article 370, which is belied not merely by constitutional practice, but the acceptance by both the state of Jammu and Kashmir and the government of India that amendments were being made to the Constitution even after 1957 and until the disputed amendment of 2019.
Just see sub-article 2.
Yes.
If the concurrence of government of state referred to in para 2 of subclause D of clause 1 or second proviso to subclause D of that clause be given before the Constituent Assembly is convened, it's purely limited.
It shall be placed before the Constitution.
Before. So, this is temporary within temporary. It is in respect of a situation where the constitution now, a state has just come in, India is now become a republic, Constituent Assembly is going to be convened soon, and if some decisions are taken to protect them, that government may do anything it wants to, state government. It may give its concurrence and its consultation, but it should be very clear whether people want it. So they said if you have done it before, then place it before the Constitution.
But then would the power of the state government to grant its concurrence under the second proviso to Clause D continue to operate once the Constituent Assembly completed its task in 1957?
What has happened is, That government also has said in their affidavit and
Or would that power be exhausted once the constituent?
all provisions of the constitution. They have applied all provisions of constitution by 1954. So really speaking, there is nothing left to be done. It is fully in operation now. 370 is fully in
But
operation.
then that is exactly.
We
But
are talking
You're
about
right,
repeal.
absolutely logically. But then why, how do you explain the fact that there were subsequent amendments to the constitution by the constituent orders?
What-
Because, the provisos to clause D refer to state government. Clause 2 refers to the constituent assembly. And clause 2 says if the consent of the government was taken before the constituent assembly was formed, you have to place it before the constituent assembly.
But a wrong practice cannot result in
But
rewriting
sir, we are talking
constitutional
of-
provision.
We're talking
They are
about the
doing-
practice over what? Over
What?
46 plus 18, 64 years.
64 years, after 64 years, you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed, then you continue with the practice. It's nobody's case.
That's completely out.
It's,
But otherwise, we will have to say,
but it is not
we will
petitioner's
have to
case
say
that
that-
no longer amendments of constitution can apply. That's not petitioner's case.
Question is, what is it that was not supposed to have been not agreed, a promise?
If the power under the proviso to clause 3 has exhausted itself, then equally the power under the two provisos to clause D has also exhausted itself.
For a moment.
In which case, how do we explain the exercise of that power for 64 years?
Looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it. Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of Sub-Article 1. No difficulty about it. Question is, can you repeal it? Can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist. The modality for exercise of the power under 370 bracket 3 is a different issue, which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power,
And there's no power to any of the COs.
what is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues, lordships are right, that time and again, Government of India is, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But, it's one thing to continue 371 and it's another to repeal 373. That's the difficulty. Nobody is not saying that the presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's
You got the point.
limited.
We'll move on.
Now just see
Just 1 minute. Just
Please see, my lord, what your lordships are saying is answered in note 371B itself, what my lord Chief Justice is rightly putting. The power of Parliament to make laws for the state shall be limited to those matters in Union List, concurrent list, which in consultation with Government of State are declared by President to correspond to matters to so and so as the matters with respect to which Dominion may make law.
So that's futuristic. May make law for the state. So any law that is made in future can be applied by the president under 371B. Then what? Such other matters in the state list as with concurrence of government of state resident may by order specify. So what? This is futuristic exercise of power by the president from time to time. Likewise, Lord, in D, such other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modification as president may by order specify. So power of president is not a surviving power to be exercised from time to time. That is why the words notwithstanding anything contained in the constitution are important in the opening of the article. Now just turn to Mr. Anger's broad segment. Please turn to broad PDF volume.
Away,
Why not?
whether under the second proviso
Yes.
to D, all the provisions of the constitution could not have been made applicable with the concurrence of the government.
Yes.
So is it not possible that if there is a concurrence of the government under D, the entire provisions of the constitution could be made applicable to Jammu and Kashmir?
There it could have been, except 370 can't be.
Except 370.
Yes, 373 is something which is left to the will of the people. There is no difficulty. Government says
Then
it.
what remains if everything under the constitution can be made applicable by exercising the powers under D?
Lord, it needs consultation and concurrence.
That's what say if
Yes.
with the concurrence of
Yes.
the question that is being
No
put is
difficulty, it can be, undoubtedly. But the power of removing Article 370 is disappeared.
is a different power.
That's an independent. And government Lord, union in its affidavit has stated that all provisions of articles of constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so.
There is no doubt that 370 has worked beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in running the administration of the state for any reason. Except national security and some violence, they have not given any other reason also. So this has worked, it must continue to work. Now why it should continue to work, please see Professor Dr. Anger's broad statement. PDF volume 8, page 1175. Words again the government of India had committed. Last para at page 1175 minutes. Lordships have got it.
Again, the government of India.
Yes. Again, the government, my
Just
Lord
one
Justice
second.
Call has got.
Just one.
Telling the learned law clerk that they are so lucky that they get opportunity to work with your lordships. When we started practice, each one of us, we didn't have that facility. We all learned on our own.
We are equally fortunate to have their assistance. They're very talented.
The quality of assistance they give, especially matters of this nature,
Yes.
it's a Herculean task just to marshal the records, and they assisted tremendously in this.
No, in fact, I had to work hard to get my intern in court today. I wrote a very personal letter to the assistant registrar and said, please, for God's sake, allow them to come in. Because they assist, their assistance is amazing and their experience, but the memories they carry back home are unbelievable. This generation of students are outstanding, these lawyers. They are far more better than my generation was. Again, the government of India have committed themselves to the people of Kashmir on certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with Republic or wish to go out of it. We also committed to ascertaining this will of the people by means of a plebiscite, provided peaceful and normal conditions were restored and impartiality of plebiscite would be guaranteed. We have also agreed that will of the people through instrument of Constituent Assembly will determine the constitution of the state as well as sphere of union jurisdiction over the state.
Now, kindly turn over and please come to Milord page, the last clause, 8 pages later. The last clause refers to what? In fact, right from top, then we come to clause 2. 1178. Then we come to clause 2.
Mr. Dave, the portion you have read is part of the Constitutional Assembly debates relating to the Indian Constitution.
Yes. Part of the Constitutional Assembly debate on 17th of October 1949.
Correct.
My lord, 1178, my lords may turn to.
1178.
Then we come to clause 2. You will remember, then we come to clause 2. You will remember that several of these clauses provide for the concurrence of government of Jammu and Kashmir state. Now these relate particularly to matters which are not mentioned in instrument of accession. And it is one of our commitments to people of government of Kashmir that no such additions would be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination of Constituent Assembly of the state. Then brought one paragraph later. The last clause refers to what may happen later on. Now see this one. We have said Article 211A, which is 238, will not apply to J&K. But that cannot be a permanent feature of the constitution of the state and hope it will not be so. So the provision is made that when the Constituent Assembly of the state has met and taken its decision both on constitution for the state and on the range of federal jurisdiction over the state, President may, on recommendation of the Constituent Assembly, issue an order that this Article 306A, which is 370, shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, recommendation of Constituent Assembly will be a condition precedent. That explains the whole of this article. Now see next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India. But the bogey is today in the country a wrong narrative that Jammu and Kashmir is not part of India because of 370. That's not so. As Jawaharlal Nehru also refuted when K.M. Shah said that yes, plebiscite. He said nothing doing. It's part and parcel of India. It's integral part of India. Unit of federal and the union legislature will get jurisdiction to enact laws on matters specified either in instrument of accession or by later addition with concurrence of government of state. And steps have to be taken for purpose of convening a Constituent Assembly in due course, which will go into matters I have referred. When it has come to a decision on the matters, it will make a recommendation to President who will either abrogate 3068 or direct that it shall apply with such modification exceptions or recommend. That, sir, is briefly description and effect of this article. I hope the House will carry it. And House carried it. Today's House has no moral or constitutional authority to undo this just because it is a majority. For the people of Jammu and Kashmir, this was the essential feature of the constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir. Because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it.
Sayaji Rao.
Sayaji Rao. I was shocked to read because Sayaji Rao is perhaps the greatest of the rulers of 20th century. I don't know whether your lordship knows or not, but the man was absolutely unbelievable. I have been telling family to have a biopic on him.
Because he was the one who sent Dr. Ambedkar for education. He was the one who always took guidance from Maharishi Aurobindo, who stayed in Baroda for many years and brought some of the greatest people. Girl child education he made compulsory in 1920s. Girl child education, free and compulsory. And I was telling Dr. Dhawan in the morning that I saw a law against water pollution which was drafted in 1920s.
So the man had a vision which was the University of Baroda, if your lordships have seen, so beautifully designed on Oxford Cambridge lines. So, and a Maharaja would not take a penny more than what was decided for him by his Diwan at the beginning of the year. That you have to only spend this much for your personal expense, he won't touch a penny after that. But he therefore didn't want to. Now just see, my learned friend wants me to read, but at page 1177 perhaps, or 1178. Now it is not case. Which page? 1177 last para.
In fact, 1178, see that one para which says, now you will recall.
Yes. That in some of the clauses of this article, we have provided concurrence of government of state field that in view of commitments already entered into between state and center, they cannot be regarded as final authorities for giving this concurrence, though they are prepared to give it in the interim period. But if they do give this concurrence, this clause provides that concurrence should be placed before Constituent Assembly when it meets, because it was not a transitional governments.
So therefore, the concurrence of the government also, in terms of the first proviso to clause D, was till the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being.
No, brother, that may
That's what he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case,
3
really speaking, there's no question of concurrence by the state government after 1957.
No.
But yet we operated that provision.
We see that on C and D at page 1177, clauses C and D refer. Your lordship, see, clauses C and D refer to provisions of Constitution. My lords have it.
Yes.
Clauses C and D refer to the provisions of the Constitution other than matters listed in List 1 and 3. These various provisions have been divided in certain categories. First, according to this draft, is Article 1 of the Constitution will automatically apply. As you know, it describes territory of India and includes amongst territories all states mentioned in Part 3. J&K is one of the states mentioned in Part 3. With regard to other provisions of the Constitution, this will apply to Jammu and Kashmir state with such exceptions and modifications as may be decided on when President issues order to that effect. That order can be issued in regard to subjects mentioned in Instrument of Accession only after consultation of Government of State. In other matters, concurrence of that government has to be taken. What your lordships read was in Part 2, because the government was an interim government. So, whether that government was rightly giving rightly giving advice or concurring, so they said let people decide to that limited extent. Now, Lord, next para. Now it is not the case, nor it is the intention of members of Kashmir government, whom I took opportunity of consulting before this draft was finalized. It is not their intention that other provisions of constitution are not to apply. Their particular point of view is that these provisions should apply only in cases where they can suitably apply, when only subjects with modifications and exceptions as particular conditions of J&K state may require. I wish to say no more about particular point at the present. So that is how the Lord he looked at it. That is how he defined. There is no other interpretation possible. This is the author. And one of the most respected, Lord, eminent citizens of this country. Or on 5th of August, President issues a proclamation. Then it is sent to Rajya Sabha. Rajya Sabha sends a recommendation without on the same day. Then Rajya Sabha approves reorganization bill on the same day. Next day it goes to Lok Sabha on the same day it is approved. But these constituent assembly debate took place over several years. These are the men and women who are most brilliant that have ever been born in this country. We owe a permanent gratitude to them. And if we were to interpret constitution as today's governments tell us, we'll be doing great disservice to these men and women. Please don't do that, Lord. They were much wiser than anybody in our generations. They knew what India's problems were. As Dr. Dhawan was at pains to point out, they knew about the diversity of this country. They felt the pain of every part of this country. And that pain they brought in various provisions. To recognize this. It's not even, the article is not just a letter. It's the feelings of people of Jammu and Kashmir.
What next, Mr.
Yes.
Davina?
Now, Lord, kindly come to, in this context, the two judgments which I respectfully submit are squarely supports the view that I have. Lord, kindly turn to PDF volume 1, isn't it? At page 8. Premnath Kaur. It's 1950.
Volume 1 of the
Yes. On October 25, 1947.
Volume
Sir,
Which page?
Swetanbhai, volume 1, page 7. Law compilation.
Para 10. Your Lordships may turn to para 10. Lordships have got it? On October 25, 1947, Maharaja signed an instrument of accession with India, which had then become an independent dominion. By first clause of instrument, the Maharaja declared that he had acceded to dominion of India with intent that Governor General of India, Dominion, Legislature and Federal Court and any other dominion authority established for purpose of dominion shall, by virtue of instrument of accession, subject always to the terms thereof and for the purposes only of dominion, exercise in relation to state of Jammu and Kashmir such functions as may be vested in them by or under Government of India Act and so on. So we may usefully refer to some of the other clauses of instrument. Then Lordships may omit all that. And please kindly, thus, last sentence of that paragraph. Thus, by the instrument of accession, Maharaja took the very important step of recognizing the fact that his state was a part of dominion of India. So this is very important, my lord. The repeal does not subserve any purpose. Jammu and Kashmir is integral part of India. Now kindly turn to my lord. Lord, please turn to paragraph. There is one more argument. Page 287. I haven't written. PDF page 15. Para 26. No, where is para? Page 16. Para 26. There is one more. No, just before that. Lord, just before the paragraph 26. Please see last sentence of para 25. We must therefore reject the argument that the execution of instrument of accession of para 26 last sentence. I'm sorry. Why are you confusing? I asked you to write this down and be carefully yesterday. Last part of para 26. We must therefore reject the argument that the execution of instrument of accession affected in any manner the legislative, executive and judicial powers in regard to government of state of which then vested in ruler of the state. So for all purposes, your Lordship's court recognized that not he was the state who wielded all the powers. And his instrument of accession didn't take away those powers. Although he became part of India. Now see, my lord, next paragraph. There is one more argument which has been heard before us on the question of Maharaja Hari Singh's powers. It said that Maharaja issued proclamation on March 5, 1948, replacing emergency administration by a popular interim government headed by Sheikh Abdullah, constituting council of ministers who were to function as cabinet and act on principle of joint responsibility. He virtually introduced a popular democratic government in state, surrendered his sovereign rights and became constitutional monarch. There is no substance in this argument. The proclamation merely shows under pressure of public opinion and as a result of difficult and delicate problem raised by tribal raid, Maharaja very wisely chose to entrust actual administration government to charge of popular cabinet. Then Lordships may omit all that and please kindly come to Lord page. Lord, since Mr. Chatterjee has resigned, page para 32. Page 18. Since Mr. Chatterjee has strongly relied on application of Article 370 of the Constitution to the state in support of his argument that Yuvraj has ceased to hold plenary legislative powers, it's necessary to examine provisions of this article and their effect. But these two judgments are a complete answer to what has happened. And these judgments bind your lordships. There is no reason to differ from this view. This article was intended to make temporary provisions with respect to state of Jammu and Kashmir, then so and so. Now, Lord, please see after the article, Lord, clause 1B of this article deals with legislative power of parliament to make laws for the state, and it prescribes limitations in that behalf. Under para 1, subclause B, clause 1, parliament has power to make laws for state in respect of matters in union list and concurrent list, which president in consultation with government of state declares to correspond to matters specified in instrument of accession. Whereas in regard to other matters in the state list, parliament may by under para 2 have power to legislate for the state after such other matters have been specified by his order by president with the concurrence of the government of the state. It is significant that para 1 refers to consultation with government of state while para 2 requires concurrence. Having thus provided for consultation with and concurrence of government of state, the explanation shows that government of state means in this what it means in this context. It means according to appellant not the Maharaja acting in his himself in his own discretion, but person who is recognized as Maharaja by president acting on advice of council of ministers for this. It is said on this explanation that appellant has placed great reliance. Subclauses C, D and 1 of article provide respectively provisions of article 1 and the present article shall apply in relation to the state, and that the other provisions of the constitution shall apply in relation to it, subject to exceptions and modifications specified by presidential orders. These provisions are likewise made subject to consultation with or concurrence of government of state respectively. Having provided for legislative power of parliament and for application of articles of constitution to the state, Article 372 prescribes that if concurrence of government of state required by relevant clauses has been given before Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly. For such decision it may take. This clause shows
This, Lord, what your lordships are rightly, Lord, worried about. This clause shows that constitutional makers attach great importance to the final decision of the Constituent Assembly and continuance of exercise of powers conferred on the Parliament and President by very relevant temporary provisions of 371 is made conditional on the final approval by said Constituent Assembly in said matters.
So Lord, 371 continues with that. Once Lord it continues, then 373 becomes OTOs. Clause 3 authorizes President to declare public notifications that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by President only if Constituent Assembly of State makes recommendations in that behalf. Thus, proviso to clause 3 also emphasizes importance which was attached to final decision of Constituent Assembly in regard to relevant matters covered by 370. My lord, please turn to next para on the same page on the said construction. Para 38. Para 38. But my lord, please omit first 10 lines or 5 lines. 5 lines. The constitution makers were obviously anxious. My lords have that? Para 38,
Yes.
fourth or fifth line.
The constitutional makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself, not by Indian Parliament.
State itself, and that is the main basis for and purport of the temporary provisions made by the present article, and so the effect of its provisions must be confined to the subject matter. It would not be permissible or legitimate to hold that by implication this article sought to impose limitations on plenary legislative powers of Maharaja. These powers had been recognized, specifically provided by the Constitution Act of the state. It was not and could not have been within contemplation of competence of constitutional makers to impinge even indirectly on the said powers. So not from Maharaja they got transferred to Constituent Assembly, those powers. So they say that you can't impinge on those powers. It would be recalled that by instrument of accession, these powers have been expressly recognized and preserved, and neither subsequent proclamation by Yuvraj Karan Singh adopting as far as applicable the proposed constitution, nor constitutional order subsequently issued by President purported to impose any limitation on said legislative powers of the ruler. Please see this. This decisions, Lord, I have completely answered long back. What form of government the state should adopt was a matter which had to be and naturally left to be decided by Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf. Now see these words. Until the Constitution Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by instrument of accession. It would therefore be unreasonable to assume that application of 370 could have affected or was intended to affect plenary powers of Maharaja in matter of governance. In our opinion, appellant's contention based on this article is therefore rejected. Lord, please turn to this para because this is a little important. It is difficult to see how this article purports. Para 40. Para 40, but not after 12 lines. The word starting with the constitutional position. And 12 lines. How many? PDF 21.
Altogether issue whether the Yuvraj could have really issued the
Sampath Prakash now.
Sampath Prakash.
Same volume. It starts at page 27 at 30. 27 at 30. The earlier page at 29, but at 30, please see the answer. Learned counsel urged, in this background, Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed.
You are reading paragraph?
Learned counsel, okay.
Page 30, para 4. Para 4.
Just the paragraph above para 5.
Yes. Learned counsel urged that this background Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed and the will of the people of J&K had been expressed, and thereafter this article must be held to have become ineffective, so that modifications made by President in exercise of powers under this article subsequent to enforcement of Constitution of state would be without any authority of law. Now please see the answer to that. Next paragraph. We are not impressed by either of these two arguments advanced by Mr. Ramamurthy. So far as historical background is concerned, Attorney General appearing on behalf of government also relied to urge that provisions of Article 370 should be held to be continuing in force. Please see that one. Mr. Daftari. Should be held to be continuing in force because situation that existed when this article was incorporated had not materially altered, and purpose of introducing this article was to empower President to exercise discretion in applying Indian Constitution. There is considerable force in this submission. Legislative history of this article cannot in these circumstances be of any assistance. That this article became ineffective after Constituent Assembly of the state had framed the Constitution.
Yeah.
Completely against you, Mr. Dave.
Please see that. There are, however, much stronger reasons for holding previous.
5, it says should be held to be continuing in force.
Yes.
And 6,
In fact, 6 and 7.
6 says that the second submission based on
2 of Article 370 does not find support even from the language of that clause, which only refers to the concurrence given by the government of the state before the Constituent Assembly
Just a
can be,
second.
and makes
Just
no
a second.
mention at all of the completion of the work of the
Does
Constituent.
not find support even from the language of that clause, which only refers to concurrence given by government before the Constituent Assembly was. That's what I'm submitting. No, that's a very limited. It's a temporary provision within a temporary provision.
But this seems to give seems to hold that the article in its entirety would continue to govern even after the Constituent Assembly had completed its task.
No, not here as a whole.
Read 7, just paragraph 7.
Let me read it now. Your Lordship may allow me to complete.
Yeah.
There are, however, much stronger
Reasons for holding that provisions of this article continued in force and remained effective even after Constituent Assembly of State had passed Constitution. The most important provision in this connection is contained in clause 3 of article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as President may by public notification provide recommendation of Constituent Assembly of State referred to in clause 2 shall be necessary before President issues. This clause clearly envisages that article will continue to be operative and can cease to be operative only if, on the recommendation of Constituent Assembly of the State, President makes a notification direction to that effect. In fact, no such recommendation was made by Constituent Assembly of the State.
nor was order made by President declaring article shall cease to be operative. On the contrary, that's important. It appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in the explanation to clause 1 of the article. This modification in the article was notified by the President by Ministerial Law Order dated 15 November 52 and laid down that from 17 November article was to be operative with substitution of new explanation for old explanation. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement to the continued operation of this article by making a recommendation it should be operative with modification only. But it can't be, you can't now resort to 373 to repeal it. Constituent Assembly has accepted it's a one-time exercise.
Not repealed.
President accepted, acted upon it.
It is not repealed, Mr.
No, it becomes inoperative.
So from time to time, this is what I said earlier, time to time COs have been issued.
No, we are not on 371. I am on 370 subarticle 3.
Even the present exercise, other argument being open, it is not removed. It has applied the other provision. As it exists in the statute of the Constitution.
No, they have repealed it. They have deleted it. They have exercised 373 to delete it.
All
The way
provisions,
it is, I'll just tell you also.
now as it stands is, all provisions of this Constitution amended from time to time when it will apply.
Yes, but they have abrogated 370 and applied all the provisions of the Constitution. Both they have done. That was not permissible. Now see further.
So Dave, we can just go a little earlier. Paragraph 4.
Yes.
First argument and the second argument that will clarify the situation.
The-
It's at page number 28 rather. The first argument was that the
First
article,
argument was that this article contained temporary provision which ceased to be effective after Constituent Assembly convened for purpose of framing Constitution of J&K had completed its task by framing Constitution. Reliance was placed on historical background in 370 included so. Then Lordships may omit. The answer is what
and then it goes also as you have done.
Now the new one.
And in this background, then it's stated that background Article Code 370 could have been intended to remain effective till the constitution of the state was framed and the people of Jammu and Kashmir had been expressed and thereafter must be ceased to have become ineffective so that modifications made by the president and
without authority. Now see the answer. I'm grateful to your Lordships. Your Lordship said no. But we are not on that. It's not our contention that 371 doesn't apply or president can't exercise powers under 370 as sub-article 1. As note recorded in at page PDF page 31 para 7. That's the answer. That it was not left to the Constituent Assembly. Otherwise, it makes mockery of the provision. If now somebody else, complete stranger, were to decide, the governor will make a recommendation, or the president will make a recommendation, or parliament will resolve. Here what they have done is that parliament resolved. That's an unusual procedure. It's neither a constituent power nor a legislative power that parliament exercised on 5th and 6th of August 2019. Parliament resolves that president may issue an order under 373 abrogating it.
extraordinary, I must say, legislative act, parliamentary act. It's neither legislative nor constitutional. It's not a constituent power.
Reading right.
Advice that because state is under president's rule, parliament therefore is constituent assembly or legislative assembly, and therefore this could be done. But Lord, it can't be, because that has come to an end. Speaking for Federal Court, Chief Justice Kanya said this, Lord, in 1949 FCR, Lord Jatindranath Gupta versus Bihar, Lordships are aware of that judgment. As a general rule, and unless it contains some special provision to the contrary, after a temporary statute has expired, no proceedings can be taken upon it as it ceases to have any further effect. 373 is that. 1949 FCR 595. It's at volume 30, plot page 18. I'm not going to trouble reading it. But this is a state, and this has been recognized subsequently. Even General Clauses Act doesn't apply. Your Lordship said to temporary. And Article 367 expressly begins with a non-obstant clause subject to the contrary. Article 367 begins with a non-obstant clause, says subject to the contrary, unless context otherwise requires. About 370, therefore, context is completely different.
Does it apply? Section 21 will apply, the court has said.
I am looking to the statute and making submission on, because federal court judgment was not granted. I'm sure you will get opportunity.
No, this judgment says that the General Clauses Act will apply. Actually.
Yes, I have seen that. I have seen that. I have marked that portion also. But my respectful submission is that here, because of the context of 373, I respectfully submit that in respect of sub-article 3, there is no question that it should apply. One judgment that I would like to place before your Lordships for consideration is, this is my second argument, that 370, sub-article 3 stood exhausted, and therefore President neither could exercise powers nor could Parliament recommend to the President to exercise that power. Just to look at the counter affidavit which has been filed on behalf of Union of India. Common counter on all, it says, it's a counter which is for all, a comprehensive counter, they call it. PDF file, common counter.
This will be in the paper book, right?
Yes.
501.7.
Oh, 501.7.
Thank you, Mr. Gordon.
501.7.
Mr. Courtmaster, kindly.
Page PDF?
2990.
2990.
Which is the internal page? Yeah, you're on the right side. The way?
The Lordships may kindly turn to page 13. Do your Lordships have page 13?
It will be 3104.
Sub para 7. 7. 7 or 8? What is it? 8. As has been explained in greater detail.
Just one second.
Para
Five.
16, Mr. Mehta.
3005.
At page 13.
Para 7.
Page 3005.
PDF,
Para 7, can you turn to para 7?
PDF 3005.
As has been explained in greater detail in later paragraphs of this affidavit, it was observed over years. Existing regime under Article 370 and exemptions modifications carried out to the provisions of Constitution of India by presidential orders issued under 371D were impeding rather than enabling, facilitating full integration of erstwhile state of Jammu and Kashmir with rest of the country, which was neither in national interest nor in interest of state of Jammu and Kashmir. How impeding? Somebody makes a statement from Home Ministry, now giving no detail as to how it has impeded. Law and order problem certainly exists, but it is not because of applicability or otherwise of the Constitution. Now, please turn over, Lord, kindly turn to paragraph, straight away to paragraph, Lord, page 18. Page 18. Part of para 8, no? Roman 5. Roman 5. Lordship said that? Page 20 perhaps, PDF page 20.
Mr. Dave, are you inviting the court to review the wisdom of the decision of the government on the abrogation of 370? So you're saying that judicial review should reassess the basis of the government's decision that it was not in the national interest to continue with Article 370.
Then Chief Justice Chandrachud said in A.K. Roy that not this theory that was developed in United States Supreme Court that political decisions courts shouldn't go into. That is now, so that was given and in Podial, your lordships expressly rejected that argument.
But judicial review would be confined to a constitutional violation. Constitutional violation, certainly it's amenable to judicial review.
Lord, I would respectfully submit that even subject.
There's no doubt that if there's a constitutional violation, this court has a jurisdiction to review. Of course, that's undoubted.
Let me put it this way. President is undoubtedly exercising powers under 370, purportedly. In Samsher Singh, your lordships have said that president can only exercise presidential power in constitutional sense. No other sense, not personal.
But the wisdom underlying the decision to abrogate.
There is no question of wisdom. President can only look at 370. President has to be advised by his advisors that 373 does not exist today.
Then we are back therefore to the constitutional argument. Constitutional argument, of course, judicial review is available, and we are addressing ourselves to that. There's no doubt about it.
Constitution. Your lordships are right.
Fraud on the Constitution.
I am on fraud on Constitution that president is today exercising a power without any material whatsoever, without any justification whatsoever, and to wish it away by simply saying that it was impeding. Well, surely this court is not going to accept that kind of a very cavalier affidavit on part of Union of India. Yes. To say
370 would.
argument was this, that these are political questions, don't go into it. Your lordship said nothing doing, we will go into them. And now after Bomai, Your lordships have expanded the horizon. Your lordships have gone to extent. Now just see two more things in this affidavit. Kindly turn to paragraph 15. It's a bundle of contradiction, their affidavit.
Paragraph 15.
Yes.
What PDF page will that be?
You
PDF 25. Oh, thank you, Mr. Gopal.
3015.
I state and submit that Constituent Assembly of erstwhile State of Jammu and Kashmir did not in any manner deviate. Please see that word. Did not in any manner deviate from provisions of Constitution of India, which would be applicable to erstwhile State of Jammu and Kashmir. Constitution of J&K adopted by this Constituent Assembly included Section 3, which unequivocally stated, State of Jammu and Kashmir is and shall be an integral part of Union of India. Additionally, Section 5 stated, executive and legislative power of state extends to all matters except those with respect to which Parliament has power to make laws for state under provisions of the Constitution of India. There can be no doubt that.
Do we really need to labor on the counter? We have to interpret the constitutional provision as it stands. How is this relevant?
Your lordships are right. I'm submitting that there are no reasons available in presidential exercise, nor are they given in counter. It's bereft of many reasons, the whole entire
That's
exercise. That's my respectful submission.
Yes.
Now see last sentence. There can be no doubt, therefore, Jammu and Kashmir became integral part of India and Constituent Assembly, an elected body, had also given its imprimatur to the provisions of Constitution of India. Now, please see in this regard, two decisions. Kindly turn to the judgment of on fraud. Just see one paragraph of this judgment.
Now, what are you referring?
This is the Constitution bench judgment in Mudaliar on fraud on the Constitution. Just see this interpretation, and then I'll take to the next.
Where will we get it, Mr. Dave?
Volume 28, case law, volume 28, page 8, and relevant part at 15. 8 at 15.
28. Case law compilation.
This leads. Oh, PDF page 19, I'm sorry.
19.
This leads us to the consideration.
Mudaliar is at internal page 7, right?
16.
Just see at page 19. Open PDF, then there is
8 at what para?
Para
16.
16. This leads us to the consideration of the question of scope of doctrine of fraud on power. In Gajpati Narayan, Justice Mukherjee, as he then was, explained the doctrine. It may be made clear that outset doctrine of colorable legislation does not involve any question of bona fides or mala fides. The whole doctrine resolves into a question of competency of a particular legislation. If legislature is competent to pass law, motives which impelled it are irrelevant. On the other hand, if legislature lacks competency, question of motive does not arise. Whether a statute is constitutional or not is thus always a question of power. Learned Judge describes how legislature may transgress the limits. Now, this is important. Such transgression may be patent, manifest, or direct, but it may also be disguised covert or indirect, and it is to this later class of cases that expression colorable legislation has been applied in certain judicial pronouncements. Now, my lord, in DC Vadva, your lordships go further, and that is at page parliamentary recommendation, my lord, in my respectful submission, suffers from complete colorable exercise of parliamentary powers. It was neither exercising constituent power under 368 nor any legislative power. Resolutions are passed by parliament on many issues, sometimes not even to honor some individuals or to say some other things or to recognize great events in the country. So parliament here passes resolution and says, Mr. President, you kindly do this. That, not in my respectful submission, is a pure act outside parliamentary broad powers. And they did it only because the assembly was dissolved, purporting to act as assembly of JNK. That we are now, since assembly is dissolved, therefore president has the powers and parliament therefore has powers under 356. Volume 19, my lord, page 118. Just one para. That one para. Lord, para 7, PDF page 131.
Which judgment is this?
Lord, this is DC Vadva.
1 second. Page, PDF page?
Of volume 19, 118 at 131.
No, that's some other judgment.
The state of
is-
Tamil Nadu.
That's state of Tamil Nadu versus Padmavati Ammal.
Volume 19,
19.
PDF 131, I think 131.
One.
Volume 19. You are referring to DC Vadva?
Yes, madam.
Yes, difference.
So we have some other judgment.
No,
Padmavati Ammal.
Yes, Padmavati.
19 page, what is the PDF page number?
Yes, it's 118 actually. It's immediately after that. It's 118.
9859.
Page 118 at 131.
131, para 7. Where does it begin?
State of Tamil Nadu.
हाँ नहीं उसके बाद में
No trouble, your lordships, reading that. The emergency power of the governor was not in the context of ordinances, but just above where Justice Mukherjee's dictum in Gajpati Narayan is cited, just above that,
at,
4 lines above that,
at page 133. Huh?
133. It is settled law. No, this is what I place for your lordship's kind consideration. It is settled law that a constitutional authority cannot do indirectly what is not permitted to directly. If there is a constitutional provision inhibiting the constitutional authority from doing an act, such provision cannot be allowed to be defeated by adoption of any subterfuge. That would clearly be a fraud on the constitutional provision. This is precisely what was pointed out by Justice Mukherjee. And that's my respectful submission that Lord and Lord Mudaliar is also considered. Now, Lord, last judgment that I placed for your lordships is the UP Assembly case, volume 13,
This was
PDF page 73.
33, page 1. This
Volume 30, PDF 73. at 92.
Volume?
Para 38. Volume 30, my lord. Volume 30. So this is the special reference.
PDF?
PDF 30. Sorry, PDF 73. Volume 30, PDF 73 at 92, para 38.
What's the name of the case?
Yeah.
What is that? Any powers, privileges and immunities of state, UP case.
What page are you referring to?
So at para 38, 92.
92.
Page 92, para 38.
Dealing with this question.
Yes, ma'am. Grateful. All your lordships have that, my lord Justice Khanna?
Just give me a minute.
Yes.
Paragraph number?
38.
38. Okay. Yes.
In
got it.
dealing with this question, it's necessary to bear in mind one fundamental feature of federal constitution. In England, parliament is sovereign, and in words of Dicey, the three distinguishing features of the principle of parliamentary sovereignty are that parliament has right to make or unmake any law whatever, that no person or body is recognized by law of England is having a right to override or set aside legislation of parliament, and that right or power of parliament extends to every part of Queen's dominion. On the other hand, essential characteristic of federalism is distribution of limited executive, legislative and judicial authority among bodies which are coordinate with independent of each other. Supremacy of constitution is a fundamental to existence of a federal state in order to prevent either the legislature of federal unit or those of the member states from destroying or impairing that delicate balance of power. That's precisely what has happened, destroyed the delicate balance of power, which satisfies the particular requirements of states which are desirous of union but not prepared to merge their individuality in unity. Lord, you can't rewrite history. And a constitutional history can certainly be never rewritten. That's why it's durability. This supremacy of constitution is protected by the authority of an independent judicial body. Your lordships. Independent judicial body to act as interpreter of a scheme of distribution of powers. Nor is any change possible in the constitution by the ordinary process of federal or state legislation. Ordinary process, 370, President issues, Parliament pass resolution.
Yes, Mr. Dev.
Thus, the dominant characteristic of British Constitution cannot be claimed by a federal constitution like ours. Then what next paragraph? Our legislature have undoubtedly plenary powers, but these powers are controlled by basic concepts of the written constitution itself and can be exercised within legislative fields allotted to their jurisdiction by 3 lists under the 7th schedule. But beyond the list, legislature cannot travel. They can no doubt exercise their plenary legislative authority and discharge their legislative functions by virtue of powers conferred on them by relevant provisions of the Constitution. But the basis of power is Constitution itself.
Yes, Mr. Dev, we read that. Thank you. Which is the next judgment, Mr. Dev?
Followed one sentence, followed in
Yes.
paragraph 40, last sentence, PDF page 93. Therefore, there can be no doubt that the sovereignty which can be claimed by Parliament in England cannot be claimed by any legislature in India in the literal absolute sense.
Yes.
So, Lord, whichever way one looks at it, but your lordships may look at the UP assembly case, or your lordships may look at Shamsher Singh's case. If not, the exercise of power by the constitution or by the parliament has to be done under the constitution itself and in the constitutional sense, then in my respectful submission, Lord, constitutional sense or constitutional provisions prohibited both the president and parliament from not touching Article 370, sub-article 3 in any manner to abrogate it. There is no power to abrogate Lord 370 under 373 because Lord, as I respectfully submitted, that Lord, it has lived its purpose, its object, and therefore it no longer is Lord available for exercise. In any case, the exercise Lord suffers from a fraud on the constitution because Lord, it has been done completely contrary to constitutional provision. And Lord, the principle of federalism, principle of democracy, which Lord Bobai has so beautifully Lord ascribed. Because ultimately, that's why Lord constitutional framers were very conscious. Let the people of Jammu and Kashmir decide how they want their relationship. They decided for all times to come. It was not a temporary exercise by Constituent Assembly. That's why I said, Lord, it would be travesty of justice that Constituent or Legislative Assembly of Jammu and Kashmir were now to be given authority to say that no, the Constitution of India will not apply to us. That power also for them stands exhausted. So those are my respectful submissions. Therefore, I respectfully submit. Lord, there is one aspect which, yes, I must tell you. Lord, in my written submissions, I have quoted Lord, from the 2019 manifesto of the Bharatiya Janata Party. In that, Lord, they expressly said that we will work towards abrogating Article 370. But in my respectful submission, this court has already said, Lord, in 2013 judgment, that these manifestos can't be contrary to constitutional scheme. One, and directed EC to issue guidelines. 2015 EC issued guidelines and told all political parties that your manifestos must be within the constitutional scheme and spirit. Now, Lord, today, because you have majority in parliament, you have done not for any purpose. So, Lord, this argument of impeding, etc., is not relevant at all. It doesn't exist. The only reason you have done it because you told people of India to vote for you because I will go and abrogate Article 370. That Lord shows that the power has been exercised for Lord colorable considerations. The actual exercise is Lord fraught with clearly Lord, I would say, irrelevant considerations which cannot apply to Lord constitutional exercise. The president is not a rubber stamp. He had to see this. Yes, you are the majority in parliament, but majority doesn't speak, Lord. It's not a constituent power. You didn't want to go, therefore, to the majority of both houses of parliament. You didn't want to do that. You didn't want to go to legislature because you are now taking away out of 5 Lok Sabha members and 4 Rajya Sabha members. Lord, once you divide territory, those members, that representation is gone. If the representation is gone by virtue of Article 368(1), you are supposed to go to all many state legislatures and take their approval. Because they are also concerned. 368 is very beautifully worded. There are so many safeguards in it. So, those are my respectful
Thanks,
submissions.
Mr. Dave.
Deeply obliged
Thank
to
you, Mr. Dave.
for
Who will argue now, Mr. Thank you,
It's been
Mr. Mr. Dwivedi will argue
it's
now.
been a privilege, grateful.
Oh, Mr. Nafri will argue.
There are a few aspects which I would like to highlight. The burden of my song is very simple. Beneath the apparent constitutionality lies the patent illegality. Now, how do I demonstrate that? So in the first place, it has been argued extensively that the effect of Constitutional Order 272 is amendment of Article 370, Clause 3. This has been extensively argued. This has been done via the route of Article 367. Now, 371D empowers the President to apply the provisions of the Constitution to Jammu and Kashmir. Now, with such exceptions and modifications, these are the words used. Now, the question that arises is whether this power to modify, whether there are any implied limitations on this power. This is the first my submission. Now, take for example, while applying the Indian Constitution to Jammu and Kashmir, the modification says Article 21 will not apply, Article 14 will not apply. Will it or will it not trouble your conscience? So therefore, my first submission is that there are implied limitations on this power to modify. And what are those limitations? We'll examine. So what have they done? Instead of Constituent Assembly, it is replaced by Legislative Assembly. Whether this is permissible, whether it falls within the ambit of the term modification, or it goes far beyond that. So if your lordships look at the Constitutional Order 272, it adds the word in the Constitution of India as it originally stands. There is no such definition. So it's an addition. I am prepared to assume for the time being that modification can take in its within its compass even addition. But the question is that you are replacing a fundamental concept, the core concept of Constituent Assembly by another legal concept known as Legislative Assembly. The fundamental difference between these two concepts is well known. Now, therefore, your lordship will see that a Legislative Assembly is a product, is a creature of Constituent Assembly. Now, therefore, in my respectful submission, this exercise is not permissible. Now, take another example, which is to be found in the judgment of Justice Khanna in Keshavananda Bharati case. I will invite your lordship's attention. His lordship had raised the question that suppose the parliament in exercise of its constituent power says that the existing parliament will continue for 50 years. Will it or will it not be a mockery? Kindly see that paragraph in the judgment of Justice Khanna. Your lordship will get it in PDF page. Yeah, I'll just. So the PDF page is 7426.
Which volume?
Is the volume? Volume 15. PDF page is 7426. No, sorry, I stand corrected. 527. 571.
Volume 15.
571.
Volume 15.
And the paragraph is 1423. Kindly see what the lordship says.
It's at page?
Page 1423. Sorry, paragraph 1423. PDF page
571.
571. I get confused between PDF page and the
Paragraph
page that I have. Paragraph 1423, sir. So this is how that para runs. Apart from the fact that the best guarantee against the abuse of power of amendment Part 3 of the Constitution. There is another aspect of the matter. Even if Part 3 may be left intact, a mockery of the entire parliamentary system can be made by amending Articles 85 and 172, which are not in Part 3, and according to which the life of the Lok Sabha and the Vidhan Sabha of the states, unless sooner dissolved, would be 5 years, and by providing that the life of existing Lok Sabha and Vidhan Sabha shall be 50 years. This would be a flagrant abuse of the power of amendment, and I refuse to believe, etc. Now, this is precisely the situation. The second judgment on which, of course, this is the only observation made in the judgment. I am not saying that this constitutes the ratio, but it is something which your lordship will bear in mind. Now, kindly see the second judgment on which I place reliance. That is Indri Delilaw's case.
Indri?
Indri Delilaw's case, and it is there in volume 25, and the PDF page starts at page 524. And I invite your lordship's attention to page 546. So on that page,
So
section
PDF,
7,
which is a PDF number?
546.
PDF number.
So on that page, your lordship will find section 7 has been quoted.
Hello?
Could you please repeat
Para
the
41 of the judgment.
page?
546.
524 I have, 546 now.
And para 41, Lord,
Which is the volume, sorry?
volume 25. Volume 25. Kindly see where their lordships have quoted the section in para 41. The provincial government may, by notification in the official gazette, extend with such restrictions and modifications as it thinks fit to the province of Delhi
Section 7.
or any part thereof, any enactment which is in force in any part of the British India at the date of such notification. Now we are concerned with the word modification. Now this has been construed by, this is a 7-bench judgment, and if your lordships come to first Chief Justice Kanial's observations on this, your lordship will come to page 726 of the PDF. The para 354, the power to modify an act in its extension by the order of the subordinate authority has also come in considerable discussion. Originally, when the power was conferred on the subordinate authority to apply existing legislation to specified area, it was given only to apply the whole or a portion thereof. That power was further expanded by giving a power to restrict its application also. In the next stage, however, was given to modify so as to adapt the same to the local conditions. It is obvious that till this stage, the clear intention was that the delegate on whom the power was conferred was only left with the discretion to apply what was considered suitable as a whole or in part, and to make adaptations which became necessary because of the local conditions. Nothing more. Only in the recent years, in some acts, power of modification is given without any words or limitations on that power. The learned Attorney General contended that the word modify, according to the Oxford Dictionary, means to limit, restrain, to assuage, to make less severe, rigorous, or decisive, to tone down.
It is also given the meaning to make partial changes, to alter without radical transformation. So this is important. He therefore contended that if the donee of the power exceeded the limits of the power of modification beyond the sense that it could be exceeding the limits of the power, and to that extent the exercise of the power may be declared invalid. He claimed that no longer a power under the term modification. On the other hand, so-and-so words expresses the word modify has been defined as meaning very extend, enlarge, limit, or restrict. It has been held that the modification implies an alteration. It may narrow or enlarge the provisions of the Power Act. It has also been pointed out that under the powers conferred by the Delhi Laws Act, the central government has extended the application of the Bombay Data Civil Pact to Delhi. The Bombay Act limits its application to poor agriculturalists whose agricultural income is less than so and so. Under the power of modification conferred by the Delhi Laws Act, the central government has removed this limit on the income, with the result that the principles, policy, and machinery to give relief to the poor peasants or agriculturists with an income of less than 500 is made applicable to Delhi to big landlords, even with an income of 20 lakhs. This shows how the word modification is understood and applied by the central government and acquiesced in
Yes,
by the
Mr.
Indian
Mantri, we've seen that, yes.
Now, this is a classic example, and this is precisely what has happened. There is a qualitative difference, conceptual difference between the Constituent Assembly and the Legislative Assembly. So the same thing has been repeated. I just give to your Lordship the paragraph numbers. That is Justice Mahajan, paragraph 414. The PDF page is 760.
Justice Vivian Bose, para 316, PDF page 698. Justice Fazal Ali, para 46, PDF page 553, and Justice Mukherjee, paragraph 155, PDF page 613. So your lordships have laid down that there are implied limitations on the power to modify. And the one classic example I gave was, suppose they say no Article 21 in Jammu Kashmir. Whether such modification can be sustained. Now, this judgment was cited in Puranlal Lakhanpal. And I want to show to your lordship what the judgment says. So kindly come to the judgment in Puranlal's case. Your lordship will find it in volume 1, PDF page 2426. Judgment was delivered by Lordship Justice Vanshu. Fortunately, there is only one judgment, so that we understand the ratio.
Volume 1.
Yeah.
Page
Otherwise,
number?
we are grappling to find out what is the ratio of Keshwanand case.
Page number?
The page is PDF page is 25.
The judgment begins at page 24 and it is in volume 1.
Now kindly see, my lord, Article 81 was modified. Now this is the modification. Article 81 shall apply to subject to the modification that the representatives of the state in the House of the People shall be appointed by the President on the recommendations of the legislature of the state. So instead of a direct election, the indirect election, that the legislature of the state shall recommend the names of persons who are to be appointed as members of the parliament to represent J&K. Now, this was impugned on the ground that the modification crosses the legitimate limits. Now, in paragraph 3, your lordships have said, on page 25, PDF page 25, this is what the paragraph 3 says. And according to me, this is the ratio. Before we consider what the word modification means in the context of Article 371, let us see what the President has actually done in the matter of modification of Article 81. The modification prescribes that the 6 seats in the House of the People from State of Jammu and Kashmir would be filled by nomination by the President on the recommendation of the legislature of the state. Now in form, the seats will be filled by nomination by the President, but in reality, what the modification provides is indirect election in place of direct election to these seats in the House of the People. The modification lays down that the President will nominate members to these 6 seats on the recommendation of the legislature of the state. The President must therefore nominate only those who have been recommended by the legislature of the state, which is elected on adult suffrage. Now, the only way the legislature can make a recommendation for this purpose is by voting. Therefore, in effect, the modification made by the President is that the 6 seats to the House of the People from the state of Jammu and Kashmir will be filled by indirect election and not by direct election. The element of election still remains in the matter of filling those seats, though it has been made indirect. In these circumstances, it may not be possible to say that there has been a radical alteration in the article. Now, this proposition itself may be debatable, but the point is that in paragraph 3, your lordships have said that there is no radical alteration. Now, in paragraph 4, then their lordships say, but assuming that the introduction of the indirect election by this nominee is a radical alteration, and that is permissible. Now, how do I deal with this para 4? So, my submission is that 2 issues arose before the court. First, whether it's a radical alteration. Second, assuming it's a radical alteration, whether it is within the ambit of 371D. Now, the second issue did arise for the court's consideration, but in my respectful submission, the determination of this issue is an obiter and not ratio. What is the difference between a ratio and an obiter? A ratio is that proposition which the court has to decide, has to lay down, so that the case is finally disposed of.
So according to you, once the court had held that this was not a radical modification, the question as to whether a radical modification is permissible really didn't arise. That was moved. Got it.
And for this purpose, I rely upon a judgment of the Bombay High Court. Unfortunately, it was not there in the, but we have circulated, I am told. And I just want to show to your lordship how Chief Justice Chagla deals with this concept of ratio and obiter.
The second aspect, what does the court, just let's see that.
The second?
The obiter, let's see the obiter.
The paragraph 4 is an obiter according to me.
Let's read that.
Yes. All right, I'll read that. But even assuming that the introduction of the indirect election by the modification is a radical alteration.
I will return after lunch.